man with the comprehension of a 10-year-old described a wound that a coroner had to open a body to find. Officers testified that nobody had told him about it. What they had told him was that his fingerprints were at the scene. There were no fingerprints. There was no match. Every word of that was invented, and every word of it was legal. His name was Barry Laffman. He was 24 years old. Nothing an officer said to him that day broke a single rule. Oxford Township, Adams County, Pennsylvania. Farm country, 2 hours west of Philadelphia, where the corn comes up to the shoulder in August. On the morning of August 13, 1987, a neighbor saw Edna Laffman out in her yard. She was 85 years old. Later that day, she was found dead inside her own house. She had been sexually assaulted. Law and Crime reported that she was beaten and suffocated. The Innocence Project and the legal scholar Brandon Garrett's exoneration record both describe the suffocation the same way: pills forced down her throat. A killing like that, in a township like that, does not stay quiet, and within weeks the state police had a name from the neighborhood. A 24-year-old man who lived nearby, with an IQ of 70, who functioned, by the assessments in his own case file, at roughly the level of a 10-year-old child. Then an officer told him that his fingerprints had been found at the scene. Barry had no way to check that. He could not ask to see the report, and he could not know there was no report to ask for. He did not know that a man in a room like this one, in another state, in another decade, had already tried to stop an interview and been talked past, and that the answer a court gave that man was sitting in the room with him now. Barry confessed. What came out of that room was a statement in his own name. It would take 16 years in a private laboratory to take apart what was wrong with it. The statement did not fit the house. He described getting in through a window that had not been disturbed. He said he killed her on August 12th, though a neighbor had seen her alive in her yard on the morning of the 13th. A confession should not need a neighbor to tell it what day it was. Then there was his blood. The victim was an A-secreter. Barry Laffman was a B-secreter, and the vaginal swab carried A-type material with no B antigen on it at all. In 1987, before DNA typing, that was the strongest exclusion science could offer. The body had already answered. Not this man. At trial, the state's chemist offered the jury a way around it. Bacteria, she speculated, can convert one blood group substance into another. Given enough time, a material could become B, and B could become A. That testimony was wrong, and the Innocence Project's record of the case says it plainly. The analyst testified incorrectly, but it was said under oath by someone the jury had every reason to trust, and the jury had in front of it a statement in Barry's name that agreed with the officers and disagreed with the swab. And there was the card the prosecution held back for last. Barry's statement contained details of the crime that the public did not have: that she had been sexually assaulted, that the pills forced into her mouth were what killed her, a wound to her head that, according to the case record, was not visible until the autopsy. Officers testified that they had never given those details to Barry or to his family. His federal complaint says otherwise. It says the details came from the officers. That claim has never been tried. On December 16, 1988, Barry Laffman was convicted of murder, rape, robbery, and burglary, and sentenced to life. 25 years old. Portland, Oregon. September 22, 1964. A man named Russell Anton Marlowe was killed, and police brought in a young Marine named Martin Frazier. Frazier did not want to talk, so an officer told him something that was not true, that his cousin, Jerry Lee Rawls, had been brought in, and that Rawls had confessed. The opinion states it without softening. The officer questioning petitioner told him, falsely, that Rawls had been brought in and that he had confessed. Then Frazier said this: "I think I had better get a lawyer before I talk anymore. I am going to get into trouble more than I am in now." The officer answered, "You can't be in any more trouble than you are in now." The questioning continued, and Frazier confessed, and he was convicted of second-degree murder. And 4.5 years later, after argument that February, Justice Thurgood Marshall handed down the opinion that answered him. One sentence has outlived everything else in the case. The fact that the police misrepresented the statements that Rawls had made is, while relevant, insufficient in our view to make this otherwise voluntary confession inadmissible. The court did not bless the lie. It weighed it and found it too light by itself to sink the confession. The test, the court said, citing Cluis versus Texas, is the totality of the circumstances. Relevant means it counts. It goes on to the scale with everything else that was in the room, and nothing on that scale decides the question alone. Two things get left out. Frazier was tried after Escobedo and before Miranda, and the court said so itself. Miranda does not apply to this case. And the line about a lawyer, the one that sounds so plain in the transcript, the court held was neither as clear nor as unambiguous as the request Escobedo had made. An officer might have taken it for a passing comment rather than a demand to stop. Frazier had been given partial warnings, and the court put those in the balance too. So the exchange in that room turns over as you listen to it a second time. The sailor asking for a lawyer was not, in law, asking. Once Miranda swallowed the rest, what survived from 1969 is narrow. A lie about the evidence, standing alone, does not make a confession inadmissible. That is the rule that was waiting in the room when an officer told Barry Laffman about a fingerprint. In 1993, DNA testing was tried. The technology of the day, PCR, DQ-alpha, came back inconclusive. It took another decade. In November 2003, the laboratory Orchid Cellmark ran YSTR testing on the same evidence, and the result excluded Barry Laffman. He was released that month to supervised home confinement. In August 2004, a new trial was granted, and on August 26, 2004, the Adams County District Attorney, Sean C. Wagner, dropped every charge. The federal court's later opinion dates the new trial and the withdrawal of charges to August 24th. The records differ by a couple of days. 16 years. He had gone in at 25 and come out at 40. He sued the men who had taken them. A federal court held that a jury could hear it. No jury ever did. Then in August 2018, the same vaginal swab that had cleared him was sent to a private laboratory, Parabon Nanolabs, for genetic genealogy. The analysis pointed to a family, a common ancestor surnamed Laffman or Spielman, and then to one man. On July 14, 2021, Adams County District Attorney Brian Sinnott announced that Christopher Spielman's DNA was, in his words, an absolute match to the crime scene evidence. Barry Laffman was 58 the day another man's name was read out in place of his own. On June 22, 2023, Chris Joseph Larry Spielman, then 59, pleaded guilty to third-degree murder and burglary and no contest to rape. Judge Thomas Campbell sentenced him to 25 to 50 years, with no parole eligibility until 2046. Barry Laffman lived to see it. He died on March 21, 2024 at Jefferson Einstein Hospital in Philadelphia at 60. He had 20 years of freedom, and almost none of them are in the record this film is built from. The paperwork keeps his conviction, his exclusion, his lawsuit, and his death, and almost nothing of the man in between. Of the 257 cases the Innocence Project has won, the average client served 16 years. The same 16. Lay those 257 sentences end to end, and they come to 4,102 years. Among exonerates convicted as children, 34% had falsely confessed, against 10% of those convicted as adults. A lie with a badge behind it roughly triples the odds that a child will confess to something they did not do. Barry Laffman was 24. The law counted him as an adult. Nothing else about him did. Legislature started with the children. Oregon Senate Bill 418, carried by Senator Chris Gorsuch, a former police officer, was signed by Governor Kate Brown on July 14, 2021. A statement taken from someone under 18 through information the officer knew to be false is presumed involuntary, and the state must prove otherwise by clear and convincing evidence. Illinois signed its own the next day. Both took effect on January 1, 2022, and by 2026, roughly 10 states have some version of it. For adults, no state has a law that generally forbids an officer from lying to your face about the evidence. There is a line, though, dirty. In State v. Kayward, decided by Florida's 2nd District Court of Appeal on November 15, 1989, officers manufactured 2 fake scientific reports, one on the letterhead of the Florida Department of Criminal Law Enforcement, one on the letterhead of a company called Life Codes, Inc., and showed the suspect a document saying his semen had been found on the victim's underwear. The court upheld the suppression of his confession. Spoken deception, it said, is one thing. Fabricated documents that impersonate a real institution have no place in the criminal justice system. Florida's Supreme Court declined review in 1990 and never ruled on the merits. They may say it. In some courts, they may not print it. Cassine and 6 colleagues in Police-Induced Confessions 2.0, published in Law and Human Behavior in 2025 and endorsed as a scientific review paper by the American Psychology Law Society, conclude that confrontational interrogation built on false evidence raises the risk that an innocent person confesses. They recommend recording interrogations end-to-end, requiring evidence-based suspicion before questioning begins, and restricting the false evidence ploy itself. In January 2019, a court in the Bronx took that research as newly discovered evidence and vacated a conviction built on a confession given at 16. A man with the comprehension of a 10-year-old is told a fingerprint has placed him at a murder. He cannot check it. He cannot demand the report. He does not know that the officer is allowed to say it, or that an opinion written before he was born had already weighed that lie and called it relevant, but not enough. Everything after that, the trial, the chemist, the life sentence, the 16 years, a laboratory in 2003, was the state spending 16 years undoing one sentence spoken in a room with the door closed. The print was invented. The permission was not. If this changed how you would answer the first question in that room, like the video and subscribe. That is all we ask. Next, they can take your car before they ever charge you with a crime. And to get it back, you have to sue your own property.